Welcome to Your Intellectual Property Matters.
Welcome to Your Intellectual Property Matters with Nolte Lackenbach Siegel. NLS has been protecting intellectual property for more than a century, helping businesses of all sizes safeguard their brands, innovations, and creative assets. My name is Kevin Rosenquist, and today I'm joined by Renee Duff, Managing Partner for the Trademark Practice and the New York office of NLS. Renee has overseen the protection and management of thousands of trademarks, copyrights, and domain names for companies ranging from Fortune 100 leaders to startups. In this episode, we'll talk about how businesses can avoid common trademark mistakes, protect their brand online, and decide when it's the right time to file. Renee, welcome.
Thank you.
So excited to talk about this. It's an interesting topic to me as someone as a creator. I'm always interested in this kind of stuff. So before we get into it, though, can you share a bit about your background and what drew you to focus your career on intellectual property law?
Sure. I come from a very creative background in photography and other visual arts. So I was actually planning to go straight to law school out of undergrad, but I got this serendipitous opportunity to work in the newly formed NBA Photos division of the National Basketball Association.
Oh, cool.
Yeah, I was a huge basketball fan. I played basketball in high school, and I was the manager of the women's Division I team at Providence College. And I was a sports editor of the newspaper, and photography was always just a hobby. So when that chance came up, all the pieces fit, and it let me combine my love of sports and creativity and this amazing environment where I got to see the business of images combined with creativity and branding up close. So it was while I was at the MBA that I really came to understand what intellectual property actually was and the power it has in protecting value and identity in a business. So it was that experience that basically ultimately sent me to law school. And by the time I got there, I knew exactly what kind of law I wanted to practice.
That's super cool. Was it hard for you to leave that kind of fun, cool job to go to like more of a desk position business kind of thing?
It was. It was a big difference. And it was funny, though, because through law school, I was able to continue working in the photography industry. And actually, at the time, it was back in the 90s and the Olympics were in Atlanta. So I actually got to go work for NBC Sports in Atlanta at the Olympics. So it all worked out.
Was that the Dream Team? Was that the original Dream Team?
It was Dream Team. So we did all those photos and that was really a great.
What an experience.
Yeah.
That's incredible. People still say it might be the best basketball team ever assembled for anything. That's pretty cool that you were a part of it.
Yeah, it was very cool.
All right. But we're not here to talk basketball. As fun as that segment was, it's really cool to get to know where you sort of came from and your roots, though. That's very, very cool. So when entrepreneurs file for a trademark on their own, what do you feel the number one mistake they make is?
The biggest mistake I usually see is entrepreneurs or people that file on their own kind of treat the trademark application like it's just a form to fill out instead of an actual legal process. And so I explained that filing for a trademark isn't like just filing for a fishing license. You don't just pay your money and automatically get permission. It's actually an adversarial process. So when you file, your application is examined by an attorney at the USPTO who's actually, looking for reasons why it shouldn't be allowed to register, including potential conflicts with existing marks. So entrepreneurs who file on their own often assume that once they hit submit, they're good and they're protected. But trademark rights are based on use and distinctiveness, not just filing the application. So I've seen people spend a lot of money on applications for names that were already in use or they were too descriptive to protect. And it's unfortunate because a little strategy and searching up front could have prevented a lot of wasted money and time and heartache. But it is almost always cheaper to get it right the first time than to try and untangle it all after the fact.
Well, especially there's other things, not just the application, but if you've put your time into getting a logo made and getting branded assets together and marketing materials and all this stuff and websites and everything else, and then all of a sudden you got to change your name. Yikes. That's tough.
Yeah, it is. It's very sad. And I hate to be that bearer of bad news for people, but it's better almost that when they see or when I see that there's a problem, even though they may have spent this money and they they love their branding.
Sure.
It's you need to fix it now rather than later when you get the cease and desist letter and it really becomes a problem.
How can a business owner know if their brand name is even able to register before spending money on an application?
So the first and most important question is whether the name is actually available. And, you can have the most creative, distinctive name in the world. And like I said, be in love with it. But if someone else is already using it, and especially in a related industry, that often is the end of that story. So before spending money on a trademark application, it's really essential to do your homework. Check the USPTO database, at least do a search on Google, and even look at social media to see who's already out there using either maybe the same or a similar name. So then once you've confirmed that the mark you want to use is available, the next thing you really need to look at is distinctiveness, because the more descriptive the name, the harder it is to protect. And we've seen that marketers love descriptive names because it's easy for consumers to understand what it is that their product does or is for.
Sure.
So if a proposed mark is important for trademark reasons or for marketing reasons, there are ways to get a descriptive mark through over time. But, we could initially register it on the supplemental register, but availability is really what comes first, and that's the foundation. And then the distinctiveness comes next, because that's what really gives your brand the strength and the value.
I've been on the USPTO website and looked up stuff. It can be a bit confusing for newbies, is sometimes it says dead or right, isn't dead the term, or it's in a different industry. If a mark is dead, is it free reign after that?
Well, that's one of these common misconceptions about a mark could be dead at the trademark office, but that could just mean that somebody didn't know. And we see this a lot with people who file on their own or don't have a trademark attorney involved. They didn't know that you needed to file maintenance documents between the 5th and the 6th year, and then after the 9th and the 10th year, and then every 10 years later. So what happens is they didn't file that. The mark gets marked as dead in the system. However, if they continue to use it, their rights continue. They're not as strong because you don't have that registration, but you don't just lose everything. And so if somebody comes in and sees, oh, it says dead, and thinks that that's the end of the story, that could be a bit of a problem.
Okay, that makes sense. Yeah, like for our purposes, if we had our trademark on our podcast title and we forgot to renew, but we kept making episodes, someone else still can't take that name.
Right. Because the big thing to remember with trademarks is that trademark rights are based on use. And so if you're using it, you're gaining what are called common law rights in it, even if you don't register it. But, the registration provides you with a whole host of other things that are very valuable in that process. But for the purpose of, someone who doesn't understand the process and is just searching at the trademark office, just because it says it's dead, it might not actually be dead.
Okay. Interesting. That's good to know. Another thing that I've noticed on the USPTO website is that it's robust. There's a lot of categories and all that. Like what kind of problems can happen if you file in the wrong class for of goods and services?
So that creates like a different kind of problem, because yes, this is something we see a lot of people going in, because again, it seems so easy. It's this form, you click the buttons and it's all
it's available. I'm going to take it, done.
Exactly.
Yeah.
And that's, you're creating a situation where you don't even know that you're creating a problem for yourself by basically choosing all of these things. Because when you file a trademark application, you need to be using it, or eventually show the trademark office that you're using it for all of the goods or services in your application. And so we see a lot of people checking all the boxes, but whether or not they're actually going to be using it for that can be a problem. And the other thing is, if you file in the wrong class and you think, this really comes in play with an intent to use application, meaning you haven't started using it yet. You're thinking about using, you have a business that will potentially do something, but so you file thinking that you're going to offer clothing, say, and then you end up, oh, you know what, we're actually going to do hair care products instead. Those are in two different classes. So if you filed for clothing and you're never going to be able to show use of clothing, then what happens is you'll never be able to get that registration through, because clothing and hair care products are in a different class. So you have to show what you're actually using the mark on,
right,
before they issue the registration.
Okay, that makes sense. That makes sense. Can you explain what a clearance search is and why it's an important step early on?
Yes, and clearance searching is a lot of people skip this step, and it's a big mistake. You can skip the clearance search. However, then you're not going to be aware of all of the things that are out there on the federal register, which is at the USPTO. But trademark rights cover federal, state, common law uses like we just talked about. So in order to find if there's any potential conflicts, the only way you're going to do that is by searching. So in a clearance search also looks at potential misspellings, different sounds, different meanings, because I get this a lot. Oh, but I'm spelling it differently. And it's like, okay, that's good. However, it's when you speak it or you see, it sounds the same. So the USPTO is going to look at the phonetics as well. So a clearance search tells you basically if the name is truly available, and it saves you the trouble of having to rebrand later on. So it is really one of the most valuable steps in the whole process. But a lot of people just skip over it, and then we have problems later.
Yeah, I would imagine so. Beyond the trademark itself, we mentioned, domain names, social media handles. Does this help strengthen a brand or protect a brand so that they can get approval?
So domain names and social media handles are not considered trademark usages in and of themselves. So the domain name, a lot of times, what that's looked at is it's like a postal address or a parking space, where your domain may include your trademark, but just because you have a term in your domain doesn't mean that you're using it as a trademark. So you kind of have to, they do all mesh together in a way, but you have to be aware of, just because you own the domain name doesn't mean that you could go out and stop other people from using that term if you're not using it yourself and that term isn't causing confusion. So it's interesting, because what happens is now there's so many TLDs. I believe there's over 1,500, and they're going to be adding more come next year. And so what we often tell people is, if the .com of whatever it is that you want to use is still available, it's not the be all end all, but it's pretty promising that, you're on the right track and we could potentially get you a trademark. But, even if you're not ready to use your mark on all the social media platforms too, one thing that we do say is, go out and get the ones that look like are going to be the most likely that you would use, because it's so much easier to get them beforehand than to have to try and get them back later, because that can be very costly and sometimes it's just not going to work.
There's a chance I could feel stupid for this, but what's a TLD?
The top level domains. So
okay, got it.
.com, .org,
Right.
.everything, but now there's over 1,500 of them. So
yeah, it's crazy. I mean, there's a everything nowadays. So yeah, there's tons of them for sure. For sure. Timing, budget, these are things that new business owners can struggle with. They're challenging. How do you help clients think through whether to file right away, to wait, or they can also do like an intent to use application, correct? How do you balance all of that?
So what we kind of look at is, there are real considerations for business owners as far as cost and timing go. So we like to take that into account because we look at a few different things. Whether you simply file, the biggest issue right now can be just to file an application. It takes quite some time to get through the process. Like currently the USPTO is looking at applications that were filed back in May, and it's October. So time is getting better, but it's definitely not a quick process. So if you're already using the mark, you can just file right away, and that's good. But if you're still in development, an intent to use application really can be a great strategy. We often, or I often explain an ITU kind of like a stock option. It reserves your right to turn it into a full registration later, but you have to take the action to actually get it registered to get the benefit. So in this case, that means, showing the PTO that you're actually using the mark in commerce with the goods or services that you applied for. So, and because trademark rights are based on use, an intent to use filing gets you in line, so to speak, and it can give you some more time. So, one of the big benefits of filing an intent to use application is that your rights will go back to the filing date. So that could actually be years before you register, but because you took that step of filing it as an intent to use application, you're going to get that benefit of that earlier filing date. So
okay. As we wrap up here, what have you seen in your career as far as what can go wrong? How bad can it get when people don't do this right, whether they ignore it completely, whether they do it on their own and don't cross all their T's and dot all their I's? Like, what kind of ramifications happen?
So one example that I share with a lot of clients that falls into sort of the category of you don't know what you don't know. So we had a client who received a cease and desist letter over the name of a supplement that they were selling. And the sender had a trademark registration. They were, and it had the shiny gold eagle seal on it. It was all good. And the sender thought that he meant he had absolute rights in that name. But when we turned around and looked into it, what it was that our client had actually been using the mark well before this other person ever even filed or claimed use of that mark. So we ended up turning around and basically filing a cancellation action against the registration. So ultimately, they were the ones who had to change their entire branding and brand. So, I actually felt a little bad for this person because, he thought he had done everything right by getting that federal registration. But what he didn't understand was how the common law rights work, and that use in commerce can create enforceable rights even without a registration. So, that's why I tell people a lot, even though the trademark application looks simple on the online form, this is an area of the law that has a lot of traps for the unwary. And if you don't know what you don't know, it unfortunately can really come back and bite you later. So, that's just one example of, and that's probably one of the more extreme examples of what we've seen can happen, but it is a great tale to tell people about, how bad things can go if you really don't know what you're doing in this area.
You're right too. Like, I made comments about how it can be a little confusing when you're looking up categories and stuff like that. The application itself, I've done it before. It's super simple. Like it's really, like, for a government form, it's really, really simple. It's not hard to understand it. So I totally understand what you're saying, that you can kind of get lulled into this comfort of that you're doing the right thing, even though there's all these things happening behind the scenes that you're unaware of.
Yeah.
All right. Well, that's it for today's episode of Your Intellectual Property Matters with Nolte Lackenbach Siegel. If you want to be confident your brand is protected the right way, from trademarks to domains and beyond, you can reach the team at www.nls.law. Thanks for listening. And don't forget to leave us a review, and subscribe to our channel. Renee, it was so great to meet you. Thanks so much for being here. Looking forward to chatting with you more.
Thank you so much. This has been fun.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.